Hello everyone, I welcome you back to our channel. This is Digo Mindset Adeba, and today we are going to attempt a question in constitutional history. Discuss Uganda as a constitutional state. So we are going to attempt this question in such a way that every person is going to understand it. When you find such a question in an exam, I beg you to answer it in a way of introduction, body, conclusion. So, what should be in your introduction? What should be in your body? And what should be in your conclusion? Hang on until the end of this video, where I shall show you all the aspects you should follow to answer this question as an A student, as a good student, as a unique student. First of all, in our introduction, we shall define what is a constitution. A constitution is the grand norm. It is the supreme law of the land. We shall also go on to define what is a constitutional state. A constitutional state is one in which powers and functions are exercised and limited by the constitution. So, we are going to define constitutionalism. What is constitutionalism? Constitutionalism in Uganda is the period from the 1962 constitution up to the 1995 constitution. So I expect you to talk about all those constitutions, the evolution of our constitution, because we did not automatically land to the 1995 constitution. As an A student, I expect you to talk about the 1962 independence constitution. In your introduction, you go on to talk about the 1966 Pigeon-Hole Constitution, the one-man constitution by Obote. You talk about the 1967 Republican Constitution. You go to the 1971 period of Idi Amin. Then you say, as per now, Uganda is following and respecting the 1995 Constitution. After that, you say, Uganda has observed the idea of being a constitutional state in a number of ways. So we are going to our body. In our body, I expect you to put the principles of a constitutional state. What are those principles of a constitutional state? There are a number of principles of a constitutional state. First of all, supremacy of the constitution, rule of law, separation of powers, independence of the judiciary, democracy, human rights, as we are going to discuss them in our video. So, to begin with, the supremacy of the constitution. What is the supremacy of the constitution? How can you talk about the supremacy of the constitution as an element of a constitutional state? Phrase it in a way that Uganda has observed and respected the constitution as the supreme law of the land, making it a constitutional state. If you are looking at supremacy of the constitution, I urge you to look at Article 2 of the 1995 Constitution, which states that the constitution is the supreme law of the land in clause 1, and all other laws derive their mandate from the 1995 Constitution. Then if you go to Article 2, clause 2 of the 1995 Constitution, it provides that the constitution is the supreme law of the land. If any other law, custom or norm is inconsistent with the provisions of the constitution, that other law, custom or norm shall be declared null and void to the extent of its inconsistency. I urge you now to look at the book of Justice Kanye Amba, Principles of Constitutional Law in Uganda, where it stated that the observance, the supremacy of the constitution is in essence that the people leading and the people being led all follow the same law. They all follow the same constitution. I hope that brings it very well. And if you go on to the case of Okawanga Semogerere versus Attorney General, in that case, the Constitutional Court emphasized Article 2 of the 1995 Constitution because it stated that in Uganda, the constitution is the supreme law of the land. All other laws derive their mandate from the 1995 constitution. If any other law is inconsistent with the constitution, it shall be null and void. If you continue to the case of Salvatore Aboki and another versus Attorney General, Salvatore Aboki was convicted of witchcraft, but Article 2 was inconsistent. Article 3, Section 3, it was a slip of a tongue. Section 3 of the divorce of the Witchcraft Act was inconsistent. It was not clear of what amounts to witchcraft, because court stated that prosecution tell us what amounts to witchcraft. If a person has a spear, if a person has a backcloth, does it amount to witchcraft? Because Article 28, Clause 7 and Clause 8 of the Constitution state that the law must be clear, the principle of legality. But however, Section 3 of the Witchcraft Act was not clear of what amounts to witchcraft, and it was scrapped off. It was declared null and void because it was inconsistent with the grand norm, the Constitution. If you continue to the case of the Uganda women lawyers versus Attorney General, the Uganda women lawyers were debating and arguing that Section 4 of the Divorce Act was inconsistent. And indeed, it was inconsistent with Article 21, which calls for equality before the law. Because Section 4 of the Divorce Act favored a man in matters of divorce. A man could only prove adultery as a ground for divorce, but a woman could prove adultery, cruelty, and others. So, Section 4 of the Divorce Act was now revised. It was made inconsistent, declared null and void. Now, let us continue and look at, you can also look at the case of Andrew Mwenda versus Attorney General, seditious offense and seditious intention, where Andrew Mwenda and his friend wrote in the newspaper exposing the president. So, they were convicted of seditious offense, but court held that they have freedom of speech and expression under Article 29 of the 1995 Constitution. So, seditious offense and seditious intention are now not offenses. They were scrapped off. They are not offenses because they were against the Constitution. And to continue, because the question said, discuss Uganda as a constitutional state, we have to criticize. We have to show some ways of how Uganda has failed to uphold the idea of being a constitutional state. And on the idea of supremacy of the Constitution, Uganda has failed to uphold supremacy of the Constitution in instances like where the Constitution is being intervened in. For example, you can see the instances where the age limit, the removal of the age limit, in the case of Malema Bidis versus Attorney General, he was arguing about the age limit. You can also look at the parliamentary term limit. Those are all violating the 1995 Constitution. So, let us now go to another principle of a constitutional state, the element of separation of powers. And if you go to Article 16 of the Declaration of Rights of Man, it states that a state in which there is no observance of separation of powers and the rule of law is not observed, that state has no constitution at all. So, does Uganda separate powers? Because the founder father of separation of powers is called Montesquieu. To Montesquieu, separation of powers meant three things: supremacy of the it meant three things. Number one, no organ of state should be led by the same individual. Each organ of state should have a different ruler. No organ shall intervene in the affairs of the other. So, independence of each organ of government. Are the organs of government in Uganda independent? Yes, they are independent. If you go to Article 128, provides for independence of the judiciary. And if you go to the aspect of each organ of state should be led by different people, you see the legislature being led by the speaker, you see the executive being led by the president, you see the judiciary being led by the chief justice. So that is the aspect of separation of powers. If powers are not separated, we shall have no constitution. The state shall not be a constitutional state. But Uganda has observed that principle to a larger extent. Now go and criticize. There are instances where separation of powers is denied. Instances where, for example, the president intervened in the case of Dr. Kizza Besigye, where he wanted to maintain Besigye being tried in a military court. He was contradicting the Chief Justice, who said that all civilians should be tried in civilian courts. So, to continue on another element, the element of rule of law. Rule of law means what? Powers and functions should be exercised in accordance with the law. So, on rule of law, we should know that it was implemented by Professor Dice. What are the ideas of Professor Dice? Professor Dice said that if a state is to have a constitution, it should have what we call absolute supremacy of the law, equality before the law. Rule of law is a topic itself, but we see it as a principle of a constitutional state. Now, what I emphasize is that go to my channel and check on our video of rule of law, borrow some points and put in your essay. And to polish it, supremacy of the constitution, we have talked about it, but equality, it is provided for under Article 21 of the 1995 Constitution. So, how has rule of law been violated? Remember I said we should give how we have observed it as a constitutional state and how we have failed. You look at the instances where people are being arrested, taken to places where we don't know. That is not ruling in accordance with the law. Instances where the president came in to tell judges to use common sense. So you check on our video. Let us now continue to democracy as another principle of a constitutional state. So does Uganda observe democracy? And if yes, it observes democracy, it is a constitutional state. And if you go to Article 59 of the 1995 Constitution, it talks about the right to vote. By that, we are exercising democracy, representation. If you continue to Article 1, which says that the people of Uganda shall choose the leaders of their own choice, it is democracy. But however, to criticize this, I want you to talk about, okay, you can even talk about Article 61, where the Electoral Commission is required, the Electoral Commission is required to hold free and fair elections. And to criticize it, you go and tell us and tell the examiner that in Uganda there is still vote tampering. It is against the constitution. Vote rigging, pre-ticked votes, vote bribery, all those are against the idea of a constitutional state. To continue to another principle of a constitutional state, that is observance of human rights. It does Uganda observe human rights provided for under the constitution? If yes, it is a constitutional state. And indeed, the Constitutional Court has come in to protect human rights of people. What are human rights? If you go to the case of, it is called Reverend Christopher Mtikira versus Attorney General of Tanzania. Court held that human rights are universal entitlements a person gets at birth and are not granted by state. There are many cases here. Major General David Tinyefunza versus Attorney General, where Tinyefunza was subjected to forced labor, as Justice Kanyei Amba said. Justice Kanyei Amba said, subjecting Tinyefunza to forced labor, maintaining him in the army was forced labor, because Tinyefunza gave there his resignation form. resignation letter. Now, why do you maintain him in the army against his will? It is against the provisions of the constitution under the right, uh, the protection from uh, forced labor. No person shall do forced labor. Now, let us continue and look at various cases. The case of Musa Nsereko versus Attorney General. Musa Nsereko was subjected to torture, severe beating while in custody. That one is against Article 24, protection from inhuman treatment, and Article 44, which provides for the non-derogable rights. So court held that that was unconstitutional. By doing that, we are protecting the idea of Uganda as a constitutional state. You can look at the right to protection of life. You talk about the case of Salvatore Aboki versus Attorney General, where he was chased away from the village, his garden was destroyed. Court held that that is unconstitutional because it threatened his right to life. You can talk about the right to protection from freedom of from torture, Article 24. You bring in the case of Mpondu Emmanuel versus Ngano High School. Mpondu Emmanuel was severely beaten by teachers at Ngano High School. You bring in those cases, and court held that that was unconstitutional. It was against Article 24, freedom from inhuman treatment, and Article 44 of the non-derogable rights. You bring in the instances where the Constitutional Court supervened. So, you can also bring in the case of Susan Kigula versus Attorney General, where she was subjected to a death penalty, but the death penalty took long to be executed. Court held that that was torture under Article 24 and 44. You look, even when a person is being subjected to the maximum punishment, death, they are still protected under the 1995 Constitution. And indeed, Uganda is a constitutional state. Now, to criticize it, I would like you to bring in instances where human rights have been violated. You talk about the arrests without reasonable excuses. Those people whom they take to basements, safe houses, car parks. It takes a person away. You no longer see him again for years. So, that is it on human rights. And we have done this video in a way of introduction, but now we are going to the conclusion. And in your conclusion, assess, tell the examiner that Uganda has largely held the idea of being a constitutional state, and indeed it is a constitutional state. However, like any human, anything, every person, everything in the world has weaknesses. It has failed in some instances. But they are less. They cannot deny the idea that Uganda is a constitutional state because it has upheld the idea of supremacy of the constitution, the idea of human rights, democracy, separation of powers, the rule of law. So, that is our video on discuss Uganda as a constitutional state. Thank you very much. This is Legal Mindset at the bar. For more reference, I urge you to look at a channel called Agora Regis with Council Ben. Thank you very much.